Welcome to the Small Business Contracts Coach.
Welcome back to the Small Business Contracts Coach with attorney Darryl Shaper of the Fixed Fee Law Firm. Darryl works with Texas small businesses to draft and review contracts clearly and efficiently, so expectations are set up front and there are no surprises later. I'm Lisa Mosbey, and today we're talking about service agreements, specifically how clear payment terms and scope definitions can prevent cash flow problems and unnecessary conflict. Welcome, Darryl. Thanks so much for joining me.
Thanks for joining me as well, Lisa. Nice to see you.
My pleasure. Darryl, payment terms often seem straightforward until they're not. What should be clearly addressed in the contract around invoices, deposits, and timing?
Well, if you think about small business, the biggest risk that you're going to face on a day-to-day basis is not getting paid for your work, right? And if you don't get paid for your work, it can destroy your profitability pretty quickly. So, a couple of things to think about here. Number one is I really recommend getting a deposit. If it's the very first time you're doing business with some counterparty and you're concerned about their credit rating or whether they are going to pay you, I get 50% of my fees generally up front and then the balance when the work is completed. That way, worst case scenario, I don't lose all of my money. That's my practice, and I recommend something like that for most service providers. When you get dealing with big companies, standard payment terms are going to be net 30, but it's crazy to me if you deal with ExxonMobil or some giant corporation, they typically ask for 60 or 90-day payment terms. So they ask you as the little small business to loan them money, which I find somewhat outrageous. And I recommend that you raise your prices to those large customers to pay for the time that you've got to be out of the money, or push back really hard and tell them. Additionally, I've found big companies often do pay even beyond their payment terms. So like they may have net 30, but they have a policy of paying 45 or 60. So you need to be aware of that when you're contracting with larger companies and potentially expect that. So again, it's frequently a good idea to raise your prices for those slow payers. And again, take deposits where you can.
Darryl, late payment clauses can feel awkward to include. How do you approach the language that protects the business without escalating tension from the beginning?
Well, it's pretty standard to have in there that they pay interest after the due date, after net 30 or immediately. And often it says the maximum legal interest rate, which in Texas is 18% a year. However, that said, most of the time, nobody fights about that language because it's almost never charged. It's almost never enforced by the service provider. And it's even if you do ask for the interest, it's almost never paid. So all of that is kind of not very important and moot. What's more important and what I strongly recommend is, as a service provider, you say, if you don't pay an invoice for more than 15 days past the due date, I'm going to stop work. So that way, if you have that right to stop work because you're not paid, if you're an important provider to that company, all of a sudden they may want to pay that bill because they want your services. So I would put in a stop work provision if we're not paid, much more important than interest charges or other late payment terms.
Something that's actionable. It makes more sense, doesn't it?
Very difficult to force somebody to pay you when they don't want to pay you. So you need some kind of real leverage, and just charging them interest on top of what they already owe you isn't real leverage.
Some agreements tie payment to milestones or deliverables. What are the pros and cons of structuring compensation that way?
I don't really like milestone payments. It sets you up for more of a dispute than if you do sort of time and materials, because they might say, oh, no, this milestone wasn't met, and for whatever reason, right? So you're more likely to have a dispute about a milestone than you are about whether you actually did the hours of work that you're charging for. So time and materials is strongly preferable in my view. That's point one. Point two is, how far out is the milestone? Is it going to take you 90 days to get to milestone one? So you get no cash in the door until you've reached the 90-day point? Or, hey, often things get delayed, not through your own fault. The client might be slow at providing you information that you need, so forth. So now more time burns off than you expected to get to that milestone. And so you're still waiting for your money. So milestones are a dangerous way to get paid. I don't recommend it. And certainly if you're getting paid on a milestone basis, I would push very, very hard for some kind of deposit. So that's the cons. The pro, I'm not sure what pro there is, except for from the customer perspective. They may like it because they know they've got something real. And as we mentioned before, I do recommend when you're dealing with a new client, doing some kind of credit check on that person before you did a milestone provision or any kind of relationship.
Yeah.
If the company has bad credit, that's just a bad sign. And you would want to get a significant deposit or payment up front if you're aware that they actually have a bad credit rating.
I can see how that would be an issue and where you'd run into that from time to time. They're structuring it for their betterment, not necessarily for yours. Can you share an example of a situation where unclear scope or vague payment terms led to conflict, and how a stronger agreement would have changed the outcome?
Yeah, I mean, payment terms are usually pretty clear, right? It's usually pretty clear, like it's due net 30, or it's due net 60, or it's due upon invoice, or it's due upon the milestone. Those are usually pretty clear, and I don't usually see a whole bunch of debate about when the payment's due. I would say that that one of the things I strongly recommend here, though, is that you get in language that says something to the effect of, hey, when I deliver an invoice, you as the customer have 10 days to object or dispute the charges on that invoice. If you don't dispute it in the 10 days, it's deemed accepted, and you agree to pay all undisputed amounts when they're due. That way you get notification earlier that they're concerned about some work or that the milestone hasn't been delivered. And so that's really important. And then it takes the undisputed amounts. Let's say you're doing 3 different things. One of them they're disputing, but the other 2 they're not. Well, you'll get paid on time for the 2 things that they're not saying there's a problem with, and that's clearly in the contract. So that's something that I would recommend. But one thing that we've talked about on this podcast before, and I think is super duper important, is it's the scope of work that is often more problematic. Are your deliverables and milestones incredibly clear and objective? Or are there words like thorough or comprehensive? I'm going to provide you a comprehensive review of your security, situation if you're a security provider. Well, what the heck does that mean, comprehensive, right? And when you put in adjectives like that, instantly the client can go, hey, I didn't find it comprehensive, and I'm not paying, or I'm going to slow pay. So that's where you really need to be careful, is on the scope of work. I try to coach my clients. The scope of work is the danger zone for you as a service provider, because if a client decides they don't want to pay, the first place they're going to look is the scope of work, and they're going to look for some nitpicky thing that they claim you didn't deliver against the deliverables or the scope of work or so forth. So anyway, I don't know if that's helpful, but that's my perspective on the areas of danger.
It really is. We need to be quantifiable, measurable. We need to have maybe numbers or certain things in there that actually show when is something completed, when is it done. Totally makes sense to me.
Yeah, exactly. And the words and the language needs to be objective, not subjective. So instead of a comprehensive security review, it's going to be, I'm going to review these three things. I'm going to review your website security and your, security practices document. And I'm going to give you feedback on those two things. That's it. Very specific. I'm going to give you feedback, and that feedback is going to be no more than 2 to 3 pages long of feedback. When you're really clear, if you deliver 2 to 3 pages on those two topics, boom, you've delivered. It's very hard to argue that you didn't deliver.
Darryl, let's switch directions for a second. Termination provisions don't get much attention up front. What should a service agreement say about ending the relationship early?
It's funny you say that they don't get in much. That is one of the most important things from my perspective is termination provisions. The two things, just to repeat something we've talked about here before as a service provider that I think are the most important are termination, and then as a service consumer, intellectual property conveyance. I want to be really clear that I own the intellectual property lock, stock, and barrel. And then for both sides, I really love the idea of making it easy to terminate for convenience. If you put in termination clauses that say, I can only terminate under these specific circumstances of whether there's a default or not, then whichever side wants to terminate needs to prove that there was a breach of the agreement of some kind that justifies this termination. From my point of view, why get in that fight? If either side wants out of a deal in a service provider agreement, as long as there's sufficient notification time, then let's let them out, right? Because I don't want to work with somebody who doesn't want to work with me, and vice versa, I hope, right? I don't want them to have to work with me if they don't want to work with me. So I allow for termination for convenience, usually with 30 days notice or 15 days notice, whatever you're comfortable with. But the key element that you have to add to that termination for convenience is that the customer must pay for the work that's completed, the time and materials you've put in, including the profits, and maybe even you add a breakup fee of some kind. If there is going to be significant demobilization costs on your side as a service provider, then you may want to charge for those demobilization costs. Or if you're going to pull a bunch of people off and you're not going to easily be able to put those people on a new project, maybe you need to charge some kind of breakup fee to cover the costs of that if you've put a lot of your company's resources into providing the services. So I think termination is super important with those and make it easy with those caveats that you're not going to get damaged as a service provider upon a termination.
Scope creep is something almost every small business has experienced. Darryl, how does a contract help prevent work from expanding beyond what's usually or originally agreed to?
Well, that's back to this statement of work, right? It's got to really clearly articulate that I'm only doing what's on the statement of work. And then if the client tries to add scope creep, then you put that in. Additionally, that's why time and materials is a much better way to bill, because it can be difficult to say no to somebody who's paying you, right? I want you to do this. I want you to do that. If that gets added into a milestone-based scope of work, is it in? Is it out? It's a little bit gray whether this work is in. If you're paid time and materials, if the client asks you to do something additional to what you're already doing, great. We're happy to do it.
And we've talked about scope a number of times. We went into a little bit of detail, but really when defining scope, what level of detail is helpful without turning the agreement into something overly complicated?
Again, it's the same point that I've made before. It's very specific. It's numbers, it's objective, it's not subjective. And, frankly, generally, less detail is better. So instead of listing out 52 specific deliverables, Again, if you missed one of the deliverables, do they now not owe you for that milestone, or do they not owe the business? So it's better to keep that number as tight and scoped as possible.
That's a valuable point. Where do we draw the line? If a small business is using the same template service agreement for every client, what are a few areas worth revisiting to make sure that it fits their current operations?
Well, the big areas that I look at for a service provider are, do you have an appropriate limitation of liability in there so that you're not exposing your company to massive liability? Do you have appropriately scoped indemnification provisions? And if you haven't revisited that template of your services agreement in the last couple of years, I would encourage you to engage me or some other lawyer, I don't care if it's me, to look at those particular things. Because in particular, one of the things that I've seen evolve over the last few years is the limitation of liability is often limited at 12-month look back of billings to that particular client, which is extraordinarily favorable to the service provider. That's the SaaS standard today for SaaS products. And that SaaS product might only cost you, let's say, $40, $50 a month. Well, that means let's just use 50. That's a $600 maximum liability that the company would have. So if you've limited your liability down that low in that kind of case, it's incredibly unlikely that somebody's going to bring any kind of lawsuit against you for a mere $600.
That wraps up this episode of the Small Business Contracts Coach. Clear service agreements help protect your time, your revenue, and your business relationships. If you're a Texas small business owner and you want your contracts reviewed or drafted, you can learn more at fixedfeelawfirm.com. If you found this episode helpful, please be sure to like, subscribe, and leave a review. We'll see you next time.
Thanks, Lisa.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.